I'm just back from a Vistage trip over in Houston where I gave a presentation on asset protection and wealth preservation planning. And a common comment came back, so I thought I would address it here on this quick little video blog. And that common question is, well, I thought my planning was already done. I did a lot of the LLCs. The difference is that they didn't take advantage or maximize the use of multi-jurisdictional LLCs. So I was in Texas. One of the attendees had multiple LLCs. They had their business and an S corporation. They had their real properties, their equipment, their intellectual property, all compartmentalized in different LLCs, which is the appropriate thing to do. I call it isolation and insulation. But the difference is they didn't take advantage of a multi-jurisdictional approach. Remember, one of the things we're trying to do is to put our clients in as strong a position for negotiating settlements as possible. And sometimes that means trying to make it not so easy and convenient for a creditor to be able to grab access to those assets. And so if you happen to be, like in this particular example, in Texas and have a Texas-based liability and they get a Texas judgment against you, all they have to do is get the sheriff in Texas, get a writ of execution. They can go in and now attack or foreclose or get charging orders against all those other Texas LLCs. The work stops there. Collection becomes a little bit easier. But if you were to take those LLCs and put them in different jurisdictions, maybe you put one in Delaware, maybe one's in Alaska, maybe one is in Nevada, all of them authorized to do business in Texas because that's where the primary activities are. At least this way, when they get a Texas-based judgment against you, now they have to go to Delaware to get that charging order domesticated, or they have to go to Alaska and get it domesticated, or they have to go to Nevada and get it domesticated. And what that requires is the hiring of another lawyer who's authorized to practice in that state. You may have to go to courts to get the Texas-based complaint domesticated. Only then will you then get the charging order because of the full faith and credit clause in the Constitution. And so a valid Texas judgment will be respected in Delaware, but it must be domesticated first, and then in Nevada, and then in Alaska. So all that we've done is we've taken the existing idea of our clients that have successfully separated their assets from liabilities and only enhanced it for the nominal additional fees for paying in those other states. You've now created another barrier for a creditor to come to try to satisfy the judgment try to satisfy the judgment. And as a result, those additional steps, those additional hurdles, all may be steps that get you closer to settlement, which is ultimately our overall asset protection objective. So if you've already taken steps towards creating an asset protection plan, and you have multiple entities, but yet you didn't fully maximize the use of multiple jurisdictions, give me a call. My name is Brad Barth. I'm a partner here at BarthCalderon, where we plan today for all of your tomorrows. Thank you for your attention. Bye-bye.